Edward Snowden first let loose his huge leak of information on the NSA and its previously secret surveillance methods back in June. In the 6 months since then, it has felt like there have been further revelations and some further political repercussions almost every week. Some of them based directly on Mr. Snowden's information, some of them in reaction to his leaked revelations. But before today, there had been no legal consequences whatsoever of those leaks and the additional information they turned up. Today, a federal district court judge in Washington, D.C. ruled that the government's secret gathering of data on U.S. phone calls is likely unconstitutional. In a preliminary injunction, the judge ordered the government to stop collecting data, not on everybody, but at least on two plaintiffs who brought the case. This is not the only challenge to NSA surveillance methods that's working its way through the courts, but this is the first one that has, forgive me, slapped the NSA upside its head and made them actually stop something that they were otherwise doing. Joining us now to help us understand the significance of this ruling is Charlie Savage, Washington reporter for the New York Times, who's been covering national security and who wrote about this development today. Charlie, Mr. Savage, thanks very much for being here.
Thanks for having me.
So this is the first time that a judge in a regular court has ruled against the NSA's surveillance program. There have been rulings before, though, or at least arguments on this subject before the FISA court, before a secret court, right?
That's right. The Secret Surveillance Court, known as the FISA court, or the FISC, has repeatedly authorized this one secret program going back to the Bush administration. But that court looks very different than this one.
In terms of the way that those court proceedings would have been different, what's the difference, I guess, procedurally between this regular U.S. District Court ruling today and what would have been argued before the secret court in the past?
Well, both involved, life-tenured Article III judges. But the way the FISA court works is only the Justice Department, only the government is allowed to come before the court and make arguments. It all happens in secret, and the court hears the government's point of view, doesn't hear any adversarial point of view, and then rules. And if the rule's in favor of the government, there's no one there to appeal. So it's a very stacked procedure when you're talking about these large programmatic surveillance programs like this call log metadata program we're talking about.
Obviously, this is just a preliminary injunction from a district court judge, the appeals court above him, and then, well, the ruling on the merits, the appeals court above him, and of course the Supreme Court. There's lots more legal wrangling that could happen even just over this one complaint. Do you think this is interesting just because it's the first of its kind, or could this be substantively significant in terms of what the NSA is allowed to do?
Well, it's an injunction, but the judge is not enforcing it right now. He's giving the government time to appeal, which he thinks will take 6 months or so. So on the ground, nothing is really going to change immediately because of this ruling. But I still think it's a big deal for a couple reasons. It's starting a conversation which will probably continue in several other similar lawsuits in other courts around the country that's going to wind its way towards the Supreme Court about whether in the modern world with smartphones ubiquitous in our pockets, we really don't have any Fourth Amendment privacy rights over our calling data and associated data like locational data. That's a principle that dates back to a 1979 Supreme Court case that the government has relied on for this program, really the dark ages of communications technology, and this may be cracking the door towards reconsidering that for the 21st century. I also think that there's been such a cascade of revelations about the NSA is doing this, the NSA is doing that, it's doing these other things overseas, it's using cookies, whatever, that the original Snowden leak, which was this program, that all Americans' phone calls, purely domestic phone calls, records of them are being collected and stored by the government for 5 years and analyzed. That really remains, for an American privacy rights perspective, the most important revelation. And it's been sort of buried under this deluge of other revelations about other programs and other stuff that's happening overseas. I think this very dramatic, long ruling today will serve to sort of re-elevate the original leak at a time when Congress is debating whether to keep it, to entrench it, to scrap it, or overhaul it in some way.
Is there anything significant about the leaks, Mr. Snowden's leak, about this program in particular, that made this court case possible? The fact that some of these things were made public and things that the government was doing were confirmed by the government for the first time after his leaks, did that allow for some of this legal wrangling to happen, or would this have happened whether or not these things had ever been admitted to?
this would not have happened if these things had not been admitted to. But without the leak, we wouldn't have known that this was happening, right? There was a USA Today article that hinted at this in 2006 and then sort of got forgotten. And there was, and the sort of what had happened to this program after the Bush administration had gone under the water. We had some senators in the intelligence committees who were warning obliquely that something strange was happening with the Patriot Act, but the government, they weren't allowed to talk about it. I'd filed a FOIA lawsuit, and a judge read what was happening in a classified in-camera by himself hearing and dismissed the case without us knowing what was going on. It took the leak by Edward Snowden to really drive this into the public consciousness, and it forced the government essentially to acknowledge what was going on, which created the opportunity for people to challenge it, as well as, because the government itself has described it as comprehensive, systematic, giving legal standing to various plaintiffs to say, well, if it's everyone's calls, it's my calls, therefore I have standing to put this before a regular court.
That standing issue has been so fascinating to watch, the way things got dismissed in the past because nobody could prove what they suspected the government was doing to them. That tipping over and changing this year, it always seemed like it was going to have big implications. Now we know. Charlie Savage, Washington reporter for the New York Times. Thanks for helping us understand this tonight. I appreciate it.
Thank you.
All right. The George Washington Bridge traffic jam story that started as the tiniest little political story in the entire world has just gotten enormous. Stay with us.